Thank you, and thank you, Gail, for mentioning children right at the end, because it's a perfect segue. So what I'm going to talk about is perhaps a niche topic, but on the other hand, I think it's really very pertinent that we are talking about an era right now that echoes the concerns that George Orwell indeed did have, and also to see how different things are. And it really is a battle of philosophies at the moment, between mainly the US and Europe, and the rest of the world is kind of follows suit one way or another, but that's really where this is happening. Europe, of course, was influenced by what happened in totalitarianism, and therefore early on came out very strongly to protect privacy with the directives and the laws that we're talking about, culminating in the GDPR. The US has always taken a different approach, more on the side of individual freedom, and therefore privacy was not seen as important. But there always has been a common law of privacy in the US, and recently there has been a lot of legislation. And in one area, and the area I'm going to talk about, the US actually has some stronger protections than the EU, and that's to do with children and those in education. So even above the age of 18, if they are in education, there are laws that are more protective in the US and in some states. So I have quite a bit of material here, so I'll try to shorten it where I can, and stick to what is most interesting and relevant, hopefully, for you in this comparative discussion. So, the interests that are, and I should add, by the way, that yes, the institution, the organization that I work for is very data rich. We are custodians of data for nearly 1.5 million students and educators, and therefore, in my function, data privacy is an eminently important area. So, the interest is to protect students and initially minors. That is the large proportion of the group. There is a countervailing interest of transparency, because data privacy can also be seen as secrecy. So what happens with data that is held by educational providers, or in our case, we provide a curriculum and control the assessment results. So in other words, the exam scores and the grades and a lot of other information about students that would be of interest to the marketplace. And I should add that there is the area of online education, which is why I mentioned specifically this is really about online data privacy. It's a $1 trillion business. This is not just about what we see now, but there is an emerging business model for education to go online, particularly higher education, but also other levels. And there are venture capitalists who are pouring money into this, and there's a lot of activity, and you can see how this links with the larger commercial world. So that's why this is a concern. There is a concern how student data and educator data gets used, and it goes in the U.S. There is even talk of a student bill of rights. So we're talking about fundamental rights for students that is being recognized as a topic. Switching back to the EU, so there was an interesting statement made, and I just caught this on television on Euronews, but Emily O'Reilly, who is the Irish ombudsman for the EU, actually has been arguing for more transparency in government records. But at the same time, she made this statement saying we have to accept the world is digital, and look at our children, look at the current generation. As Hugh also said, we've basically given up the right to privacy. There is almost no concept initially, and the education, the current generation, my children have to learn what it actually means and what they're actually giving up. But they have a very different concept of this in the digital world, and the laws have not been catching up to deal with this in many cases. So we have to think about what should it be, how much privacy should there be. But I believe for students it's very important. So there's an organization called the Electronic Privacy Information Center. It has a lot of very renowned academics and legal practitioners who are on their advisory panel. If you go to their website, you see the involvement. And they make this statement, students don't just give up their rights to privacy at the schoolhouse gate. However, that is something that happens in various ways in many cultures and countries. In the US even, military recruiters have access to student data unless there's an opt-out. So in that sense, it's like we've been saying, the US is less protective of privacy in that area. However, there's a lot of activist voice for that to be changing. There are various federal statutes on privacy in education, starting with the FERPA, which is the Family and Education Rights Act, which was passed a long time ago and therefore is outdated. And there were other acts that followed, which I'll talk about. And so if we talk about FERPA just briefly, just to give you an understanding of what these laws are, because you'll see them if you're doing contracts and they involve privacy with U.S. entities, has anything to do with families or education, you'll come across these kind of provisions. Basically gives the parents the rights to the students' data. And they also only apply if there has been somewhere federal funding, but that link can often be found in the U.S. school system, but also potentially abroad. Main controversial aspect is there are no fixed penalties. So how effective this law is, that's really, that's not that can be questioned. It does provide a number of rights, including a right to file a complaint and to demand consent. So as that law was in place for a while, there has been since then an online Privacy Protection Act called COPPA, and that does now, on its terms, apply extraterritorially. So and it does have fines. So there's already something with a lot of teeth, and there has been enforcement of this, and there are amendments to create. At the moment, it's age 13, so parental consent is required under 13s, but it's being pushed up to 16 years old potentially, and there is a problem that has been recognized there. And there's another law that's more about protecting children from inappropriate material in the U.S. Called the Children's Internet Protection Act. Then very recently, President Obama passed a law called the Every Student Succeeds Act. That's not specifically focused on privacy, but it is being relied on to link to privacy concerns. And it's interesting in the statement that the president made that he says, the fundamental ideal is that every child, regardless of race, income, background, and zip code where they live, deserves a chance to make their lives what they will. Now, those factors, those criteria he mentions, of course, are typical privacy criteria. You can't have equality, I would say, without a right to privacy. It's very much linked. Just to point out the new thinking that you can see in the U.S. Now, in response to the inadequacies of the federal laws, even though there are a number of federal laws, as I pointed out, on children and education, the states have jumped in, and being led by California in 2014, there's been a wave of U.S. state legislation to essentially provide privacy protections similar to what you would have in the EU, or even a little bit stronger. So the California law is called the Student Online Personal Information Protection Act, quite an extensive privacy law. California is one of those countries that has a civil code and statutes, and leads the way. I'm not a California lawyer, by the way. I'm a New York lawyer originally, but still, from the beginning of my career, I've dealt a lot with California legal issues, including privacy. So I'll not go into too much detail over that. Just point out also that, that there still also is the common law, and there are big lawsuits that are brought in the name of privacy and students. One against essentially a competitor of our organization, the College Board, which provides the SAT tests and advanced placement in the United States and outside the United States as well. So their students were bringing an action, a class action, that the College Board was profiting from their data and actually selling it for a certain specified amount and making a very nice profit on that. That particular lawsuit didn't succeed because of a lack of being able to show damages. So there again is the weakness a little bit of the common law from a student point of view. However, there are other cases like this that have been successful, so it always depends on the facts. Again, summarizing the states, there's more legislation on the way, and in the last 2 years, 36 states have passed bills, 25 more have introduced legislation or bills modeled on the California law. You could maybe say this is all a reaction also to the NSA surveillance and the Patriot Act and these kind of movements in the U.S. It really is an interesting shift, I think, in thinking and generating fears in people. And so I think privacy law is becoming stronger in the U.S. Also in Canada, and in the U.S. and Canada both, you have this issue of states demanding information of students, for instance, in exchange for food stamp or food voucher programs. They then want to know who those students are. And our organization does not just hand over that data, but we negotiate data sharing agreements with the governments and make sure that we actually get them to sign that they'll comply with EU and other data protection laws. So they want the data. They can't. We don't take the position they can just have it. I think that's quite important, and we get approached by governments all over the world in that sort of way. Maybe a few more salient points of the California law. So it restricts selling to students, selling student data for commercial purposes. Doesn't define what selling means, and so there probably will be litigation around this in the future. One could imagine there is an exception if it's for educational purposes, but what are they really trying to achieve? They're trying to, you have to look into the legislative history for that, but they're trying to deal with children that sit at their computer and they get sold apps that maybe have an educational flavor to them, but in exchange for that, they're giving up data. They're giving up a lot of things, maybe even their school data related to their school. So that they wanted to stop, and the building of profiles that might be of interest to employers, because there were a number of cases where that was happening and indiscriminately being sold. So now it's a very strong act there in the legislative history. Also, there's the Assembly talked about the fact that personal information is considered sacred, and companies should not be allowed to operate in an unrestricted way. And security of personal information, of personal data, has to be above private profit. So that came through loud and clear in that statute. There's even a question whether consent would be valid, because there's no specific provision in the statute that you could give consent to sell the information. So whether parents or students or educators could actually validly ever do that is something that's a question. The materials, by the way, I'm happy to make them available, so I might skip over some things here, but happy to share that. And I will just move on from California. Now, again, looking at the EU, you have the right to be forgotten, and my thought there is, would that apply to student data? And my question is really, what does the EU do about student data? And it's not that specific. There is nothing so specific in the GDPR compared to what you find in the US. So I think there is a challenge for compliance, for being able to meet both standards, especially in a global world where everything is in the cloud anyhow, and you have to write your agreements and privacy policies for that. So student data mining, that is the concern in the US that has been addressed by the states in part, but activists want to go further and are warning about the risks and warning, in fact, the US Education Department, which is trying to assemble databases of student information. Again, what happens to that data? There need to be more restrictions around it. So that has triggered the call for the student Privacy Bill of Rights, which would provide additional safeguards and also emphasize data security, which is really the big area for data. It's really about technologically, how do you protect the data once it's out there in the cloud. There's also a question on risks with research. We have a lot of requests for research with our student data, and we're very cautious with that and only do that, again, in exchange for security given in research agreements. And even then, it's anonymized and aggregated data that we would ever release. But the U.S. Education Department is potentially, collecting things like disciplinary data, and again, this organization, EPIC, is warning against that and having a voice in this area. And even as recently as actually this week, a petition was filed by legal scholars, technical experts, and many others to come up with a data security rule to actually protect student records, so that there's a clear standard and also encryption and breach notification is defined. So that's something that hopefully will progress. General point is that you should always be aware of aggregate and anonymized data being what could be shared to avoid breach of data protection, but you have to be careful that it is truly anonymized, and there is material on the European Commission's website about how that might not be the case. If you have a group of just one student in one subject, for instance, then they're defined, and it's no longer anonymized, even if that it's the name is withheld. So that's an area to be cautious about. Then comparing the age of consent for giving away private data. The GDPR does have something there, so it's moving in this direction of also considering children's data in Article 8, requiring parental consent, and has recently been changed, or in the final draft it was changed to be a 16-year-old threshold. So at the moment it's not consistent with US law. And this will continue to provide challenges for companies providing international services. I'm at the end of the presentation. I'd like to open up for questions. And thank you for your interest, and anything on this topic I'm happy to discuss. Thank you.
Thanks, Alfred. I suppose on a point that I was alluding to at the start, the generation now of children we need to protect them from themselves about what data they share openly and freely, and all the regulations seem to be aimed at as if the starting point is that you are aware of your rights, your privacy rights, and these are privacy rights that you value as well. Is there difficulties in legislating for children who don't really care about their privacy?
Well, that's a very good question, Hugh. The focus of the legislation has been on the idea of not trying to block students and children from releasing their data without parental consent. So in other words, it's bringing in the parents or guardians to as the control point. But yes, there is a larger question of how do you actually educate the children or make them aware of their rights in this respect, and how do you practically avoid that they bypass, let's say, if a child sits at a computer and finds a way to bypass something or manufactures consent, how do you even achieve that? So I think there's some big questions around practically what needs to happen.
And if you were finding yourself that inadvertently someone has, some child has released data onto your platform or into whatever company you're providing, and is there anything that they can do to prevent that in the first place, or what could companies practically do to stop that from happening?
Well, I think, the issue is, how can you be compliant? And so you have to put in safeguards. Obviously, I would recommend having an opt-in process where there has to be an active opt-in. There has to be a very clear notice of the privacy policy and that it's what's applicable to minors. But then once they're in, also you also have to have your own process to try and filter that out and go back and not accept data that hasn't been through that process. So you have to have a good system to potentially detect it. Not sure if that's always possible. But I think in terms of a defense against a compliance action, then you want to look very carefully that you're at least considering this issue and building it in as much as you can.
And our laws seem to be very much moving towards we need consent, and that seems to be the point of focus. Perhaps should we maybe be focusing more on the requirement to encrypt data? I mean, schools will always need to have huge amounts of data on children just to run, but how they could perhaps encrypt the data.
That's right. That's the push of that data security petition that I mentioned towards the end. That's exactly what that's aiming for. So it's absolutely critical that data security is there. One thing I didn't mention, by the way, is that there is cybersecurity insurance, and that may cover some things like this. So just as another interesting area, I think it's been recognized as a risk. There's insurance for it, but as part of that insurance, you're required to, as we have insurance like that, you're required to put things in place so that you're compliant with laws as they are. But once you have that, if there then is a breach and you've done everything possible, within your power to prevent it, then the insurance would be effective.
Great. Does anyone have any questions from the audience?
Thank you. Am I correct in understanding that there's a fundamental problem that it's a fundamental problem that people who put out pictures and literary stuff on the internet also transfers title or IP rights to someone else? I mean, to Facebook, to Google, and to other large institutions, and by consequence of that, they are deprived of protecting themselves from then on.
Yeah, I mean, it's not. There is an issue of IP rights, but that's separate from that. It's really personal information. So it's the name or the preferences of an individual, let's say, or the grades of a student, or their hobbies, or who their friends are, that sort of information. Once it's out there, that's right. Once it's disclosed to Facebook, and assuming if there was something to click to accept terms and so forth, maybe that happened. But yes, once it's out there, it is essentially lost unless unless Facebook wasn't compliant, which is exactly the lawsuit that Max Schrems, the student, by the way, law student, right, brought to say it wasn't right what was happening, but that is a risk. That is a risk. So,
Well, thank you both very much. I hope everybody found that as interesting as I did. And I think we got a little something for both of you here.